and native Houstonian. He's been a peace officer, also served on the Houston City Council, and he's really stood for the fact that hard work, honesty, and public service are the keys in providing leadership for this county. So it's a real pleasure for us to welcome Sheriff Adrian Garcia. Thanks so much.
Thank you so very much, and once again, thank you all for bringing us all together and for all the respective work that the Texas Public Policy Foundation and the Laura and John Arnold Foundation are doing to create a very, very important dialogue on public safety. You know, and David's comments were really important, and it just made me think of some of the initiatives that we've worked to do. But first of all, with the respective initiatives that we put in place, since 2009, we have affected about over $112 million operational savings in the Sheriff's Office. Coupled with the fact that when I took office, we had a jail population that was 11,400 at its peak, and we're averaging about 8,800 these days. But all that has been accomplished through respective initiatives. We took a shot at electronic monitoring, encouraging the judges to sentence folks to the opportunity to have them evaluated and put it on electronic monitoring. That didn't go as well as we expected, but we're going to continue to take a shot at it and encourage more of it. But and then with his remarks about human trafficking, it's not often that government supports government, but I gave $300,000 of my seized forfeiture to the juvenile detention center so that they can stand up a program to help those teenage victims of human trafficking. So we have to continue to think in that regard, and crisis intervention response teams have been talked about since we've stood up that particular program. It is they've instituted about 2,200 emergency detention orders. They have effectively jail diverted about over 800 people from coming to the county jail, all of which I think has contributed to the success that we're having in terms of reducing the jail population. Coupled with the fact that we have taken important efforts at dealing with the prostitution population, in that number one, we're taking a shot at lowering the demand, not just making touting our success on the number of arrests of women who I believe are principally the victims of prostitution. But in that regard, we instituted a program called Been There, Done That, which is a person who has had a rags to riches kind of story. She's walked the walk and suffered as regard, but has pulled herself up from her bootstraps, and now is an incredible life changer for the women in our facility as well as the men. We're working with the men in our respective facilities. But it is my pleasure and always my honor to share the dais with our district attorney, and I appreciate her leadership in all aspects, and I look forward to continuing to work with her, as well as all the distinguished members. But my points are to talk about the risk assessment and bonding schedule, the recidivism study that has been completed, the idea of pretrial information sharing, and what important opportunities there is with the legislative session coming into session. On the risk assessment and bonding schedule, I think good policy. I think that there's good reentry. I think that good providing good bonds all should equal good public safety. And so one of the things that we did to also help lower the jail population was institute an additional credit, what we call the earned early release credit, for inmates who get educated, get their GEDs, get their vocational certifications, or put in a good day's work. Obviously, the folks who are of least risk to the community, and if they play by the rules, work hard, do everything we ask them to do, then they get an extra day's credit for time served. And that has had a significant impact. And so the recidivism study that I mentioned, I had been looking for quantitative and effective measurement of those particular programs that I believe will demonstrate the success of them. The vendor done that program, just as a comparison, in 2 years or so, is averaging something like an 85% non-reoffend rate. That's phenomenal. And so, once again, if we can put former inmates on a trajectory to a better, positive, more productive direction, means less victims, at least less law enforcement and correctional services, and less prosecution services or resources expended as well. But all that also has to do with the fact that a significant portion of my population is on pretrial status. And I have been advocating for us to take a look at how we make the decisions on who to give bonds to. There's a lot of conversation about the fact that the people that are on pretrial status have criminal histories. I understand that. But we have to peel the onions. We have to really drill down into the details to evaluate whether or not there are more bonding opportunities that we can provide and affect that pretrial status more. My thought in that is simply a little bit like, we want people to learn from what the experience they're going through. And, if we don't want, homes to be foreclosed on, we don't want people to be put on welfare, we don't want all these other residual effects, then if individuals have employment and have some degree of sustainability and stabilization in their lives, we ought to figure out how to make pretrial work in that regard. And so, and then the other side of it too is that there's two different instruments being collected right now, that by pretrial services and that by the sheriff's office in terms of classification. I think we have to blur the lines so that we are collecting as much succinct and empirical data on a global perspective so that we can make effective decisions all the way around, make those decisions in real time, and I think make the overall system work much more effectively. Coupled with the fact that the legislation, as it was being, some of the medical costs and those things that were being asked earlier. Today in Texas, for those of you who are not from Texas, it may be interesting for you to realize that you spend over, 29 days in my jail, your Medicaid is canceled. Not suspended, but canceled. And then, if you qualify for Medicaid, then you have to have the skill set to reapply and requalify and go through that bureaucracy. Given the fact that a significant number of the people that this could impact are mentally ill and homeless. And so it doesn't make a damn bit of sense. We have to figure that out because ultimately, as it said, the cost that's put on the local taxpayers, the amount of work and money that we're spending in the county jail to stabilize folks, get them moving in a better direction, just to have them leave the jail and then only have an emergency room or a patrol car to get treatment. That's wrong. It doesn't make any sense. It's not cost effective. And so I think we have to take a look at that. And so in closing, I'll just say that we have made a lot of progress. But progress does not happen. And as David was saying, do something. My term is let's think about wild ass ideas. WAI, the philosophy of my you just got to be willing and have a bit of courage to do something that hasn't been done just because it's never been done, or do something again that's been tried but maybe needs to have some degree of re-engineering so you get it right the next time. We shouldn't be afraid of taking different bites at the apple to get better results. Thank y'all very much.
Well, I really appreciate the sheriff. I know he does have an appointment, but thank you so much. I wanted to just go ahead and make a few comments that I would have made at the beginning, but we have a paper for you that's on your chairs that we did on Texas Solutions for County Jails. And some of the issues that we addressed in there, of course, have already been discussed here today in terms of a risk assessment, re-examining bond schedules, seeing whether perhaps there's some technical probation violators, particularly those who are nonviolent and low risk, who could be bonded out. Currently, on the bond schedule here and elsewhere, technical violators or any probation violators cannot bond out. Ensure that the courts have mitigating information when they're looking at perhaps raising bail, for example, or lowering bail, that the positive information about the defendant is before the court in addition to the other information. And, I think one of the really interesting things is the possibility of converting some civil courts to criminal ones, because there's a real dearth of civil litigation. But yet the criminal courts are much busier. And of course, there's probably some political barriers to that, but it certainly would seem to be something we should look at. Obviously, the cite and summons law that was passed in 2007, how that can be implemented. And as we go down the list, looking at things like GPS, substance abuse treatment, including medication-assisted treatment, and the jail reentry, including basic things like making sure people have a photo ID when they leave jail. So those are all things that we talked about in that report and other publications that we've done. And I think it's been really encouraging to see the progress that Sheriff Garcia and others have identified here in Harris County. By the same token, I think the sheriff was right to say there's more work to be done. And obviously, historically, the jail population here tends to go up by about 1,000 during the summer. There is a variance, we've been long-standing, a number of variances from the Jail Standards Commission for Harris County in terms of extra cots and such. And so obviously, once the summer is upon us, those numbers will likely, if it follows historical trends, go well over 9,000, perhaps close to 10,000. So, but again, as the sheriff and Dave LeBon said, we have to make sure we're doing things that are both good for public safety and address the issues in terms of the cost of the jail. So with that, let me turn to our next speaker today, and we're very pleased that Matt Alsdorf is here from the Laura and John Arnold Foundation. He's Director of Criminal Justice there. He was previously an attorney in white-collar cases. He represented both victims and defendants in many cases involving financial fraud. He's also taught criminal procedure at Fordham Law School and developed and taught a Yale College seminar on constitutional law. Before becoming an attorney, Matt served as law clerk for Judge Denise Coate of the United States District Court in Manhattan, and also was a journalist. So please join me in welcoming Matt Alsdorf.
Thank you so much, Mark, and thank you all for having me here. I'm really looking forward to talking to you today and having a discussion with the other panelists about how to make the best decisions about who really belongs in our jails and who can safely be managed in the community. Before I talk about exactly how the Laura and John Arnold Foundation has approached this issue, let me talk a little bit about how we got involved in these questions in the first place and why we believe it matters so much to public safety, cost effectiveness, and fairness. So I joined the foundation about 3.5 years ago along with Ann Milgram, who, as many of you know, is a former Attorney General of the state of New Jersey. Before that, she was a career prosecutor at the state, federal, and local levels. At the point where we joined the foundation, the board was really looking to expand its role in the world of criminal justice. And we were tasked with working with them to identify the areas where the foundation could have the biggest impact. And when I say the biggest impact, we're thinking always first and foremost about public safety, but also making the best use of public resources and ensuring that the system operates as fairly as possible. In our discussions with the board, it actually didn't take us too long to come to the conclusion that one of the areas we should focus on is the front end of the system, which we define, it's sort of pretrial, but it's broader than that, or at least broader than the way pretrial has typically been defined. It's everything from arrest up until case disposition. And we believe that was where reform could make some of the biggest difference. Our thinking was really that if we want to make the right decisions about who belongs in the system and who can be out, let's make those decisions as early as possible. But the challenge that we found when we started to dig into these issues was that a lot of the key issues at the front end of the system, so things like who to detain, who to release, who even to arrest in the first place, those decisions are often made with limited access to critical information and objective data that would help police, prosecutors, judges, and others figure out which defendants pose a significant risk to public safety and which do not. As a result, what we see when we look at who's in our jails awaiting trial, what we see is that a significant number of low-risk, non-violent defendants are spending long periods behind bars before trial. And on the other end of the spectrum, a surprising percentage of high-risk and sometimes even violent defendants are getting out quickly. The consequences of this for the public safety and for budgets clearly are not good. So we wanted to find a way to change the status quo to ensure that when judges make a decision about pretrial release or detention, they have access to a tool that provides objective, data-driven information, basically a pretrial risk assessment, which you've heard referred to this morning a number of times, but a pretrial risk assessment that would provide them with information about the danger a defendant poses of failing to appear in court if he's released, and the risk that he will commit a new crime, particularly a crime of violence if released. Right now, only a small minority of jurisdictions use this type of instrument. The estimates we've heard is less than 10%. And it will surprise probably no one in this room to hear that the main reason that more jurisdictions don't use these tools is cost. There had been a prevailing view that using risk assessment, or that developing risk assessments had to be done individually in each jurisdiction, that if you developed one in Houston, you couldn't take it to Dallas, much less to Seattle or New York. The other thing that was making them costly is that each defendant needed to be interviewed. That obviously results in staffing levels that are out of the reach of many jurisdictions. So what we wanted to do is see if we could develop a risk assessment that could be equally effective and accurate anywhere in the country, and that would not be so costly to administer. So there's more information about this in more detail on our site, and I'm happy to answer questions about it, but just quickly an overview of what we developed. The risk assessment we developed is called the PSA Court, or Public Safety Assessment Court. We developed it based on a large data set of about 1.5 million cases from 300 cities, counties, and all of the federal districts from across the country. We were able, because the data set was so large and diverse, we were able to look at an incredible range of risk factors. So everything you could think of: demographics, current offense, criminal history, employment, housing stability, etc. And we tested hundreds of correlations between these risk factors and the outcomes that we care about, namely new crime, new violent crime, and failure to appear, and identified the factors that are most predictive of each of these outcomes. And what we found is that with 9 data points on a given defendant, we could create a risk assessment, the PSA Court, that was equally or more predictive than existing tools, and one that for the first time did not require a defendant interview. And another first is that it predicted violence. It gave a separate risk score for the risk that a defendant would commit a violent crime, not just any crime. And of real importance, right, it didn't involve an interview. And this is actually consistent with prior research, which showed that the most predictive, the most powerful factors have to do with criminal history and prior incarceration and things like that. So the more subjective factors, the ones that require an interview, housing, employment, drug use, etc., are not part of this risk assessment. We've now validated it in a number of additional jurisdictions, ones that didn't give us data the first time around, so they're entirely independent, and found that it is a very predictive tool across jurisdictions, across regions, and for all 3 of the outcomes we care about: failure to appear, violence, and new crime. We have been piloting it in Kentucky for the last 1.5 years throughout the state, and I'm sure that Tara will refer to some of the results that they've seen. It's been, I think, a very powerful tool there. One, the pretrial crime has decreased since they started using the tool, and the percentage of defendants released has increased slightly, which we think is a very positive outcome. We're also piloting it in 5 counties in Arizona, Santa Cruz, California, and in Mecklenburg, Charlotte, North Carolina. We anticipate having data from those pilots probably in the spring of the coming year. One thing that I do want to emphasize, and it echoes something that Dave Laban said earlier this morning, is about judicial discretion. Risk assessments do not replace judicial discretion. It doesn't change the role of a judge. Because really there are 2 separate questions. There's the question of what risk a defendant poses, how risky is he, and what kind of risk does he pose. That's question 1. Question 2 is what do you do about that, right? What are the strategies that you can use to mitigate or manage that risk? And depending on the jurisdiction, judges have various tools for answering that second question, right? The first question we help to answer with a risk assessment. The second question of what do you do about it That is varies by jurisdiction, but judges typically have a variety of tools. Sometimes it's money bail, could be electronic monitoring, could be supervision, drug testing. I mean, there are a bunch of different things, and it all depends on the jurisdiction, what judges have available to them. But it remains up to the judge to determine in each individual case which of those risk mitigation strategies or tools they would want to impose. Finally, we are also working at the foundation on tools, I think that Dave Levon referenced this as well, for prosecutors and thinking about ones for police. Similarly, what we would like to do is be able to help guide their decisions so that they are more informed by the risks that a given defendant poses, so that when a cop is making a decision about whether to cite and release or to arrest the defendant, he or she has information about the risk level of the defendant. And likewise for prosecutors, obviously they make a ton of crucial decisions up front about charging, diversion, deferred prosecution, plea arrangements, recommendations to court about release and detention. And we are about to pilot in a couple of jurisdictions a risk assessment for them that could help inform those crucial decisions. I'm happy to answer, obviously, any questions about these assessments and our strategy overall during the discussion period, but my time is up. So thank you very much.
Okay, great. Thanks so much, Matt. Our next speaker is Tara Bo-Flute, who is the General Manager of the Kentucky Court of Justice, Administrative Office of the Courts, Division of Pretrial Services. She has extensive experience developing program and mission goals and objectives, pretrial assessment, and data management. She led the design of the pretrial case management system there called Pretrial Release Information Management, designed pretrial monthly reports, program insurance protocols, performance and outcome measures. Please join me in welcoming Tara Bo-Flute.
I only have 8 to 10 minutes to give you all a 4-hour presentation. So I'm going through this as quickly as I can, and I'd be happy again to answer any questions when we get to the discussion part. Really quick, Kentucky pretrial has been around for a long time. We were created in 1976 as part of the bail bond reform act when commercial bail was abolished. So in Kentucky, we have a statewide pretrial agency that's housed with the judicial branch of government. So we're actually in that third branch, and we are with the Administrative Office of the Court. So we're a state agency. Our counties, the jails in the counties are run by the counties. So of course the counties love us. The state pays for us, and everybody that we get released from jail, the county doesn't have to pay for. So it's a win-win for us. There's 288 employees in Kentucky Pretrial Services, over 50 programs on all 120 counties. We are we're a large program, but we don't cost very much. My entire budget to provide pretrial services for the entire state, with 288, including me, is only $12 million. So we're able to provide pretrial services. Every defendant that's arrested, we interview, do the risk assessment within 24 hours of that arrest, and is presented to a judge for a bail decision. When people are arrested, they don't have a preset bail unless there's a warrant. So we talk to them within 24 hours and have that decision very quickly. We do investigation, court supervision, and diversion. I'm going to talk a little bit about supervision before I show you the numbers. We don't supervise a lot of people, and that's intentional. It's very taxing on our resources. When you get into pretrial supervision, it's very expensive. We would not be able to service all 120 counties if we supervised everybody. We supervise about 10% of the release population, and that's reserved for the highest risk defendants. Now, we do have some orders where judges put conditions on lower risk people, but for the most part, we reserve supervision for the higher risk because most people can't be released without supervision. So to give you an idea of our numbers, I pulled this data just yesterday, or the day before yesterday, and this is for the past 12 months that's available. We had 252,000 arrests in Kentucky, of which 68% were given pretrial release. Of that 68% that were released, almost 65% of them were released on recognizance, no money. No money bail. So overwhelmingly, they're released on their own word, and they come back to court, and they don't commit new offenses. Of those that were given money bail, most of those are low bail amounts that the defendant's able to pay, and the money is actually paid to the court and then returned to the defendant when their case is over. We did have about 22% that were unable to make bail. Their case was disposed of, but they sat in jail more than 48 hours. Another 7%, their cases were disposed of within 48 hours. So they didn't get pretrial release. Basically, there was a money bail set that they could not make. but yet their case was disposed of rather quickly. And as of the 10th, there was 3% of those 252 that remain in jail right now awaiting trial, unable to make bail. So overwhelmingly, a majority of defendants in Kentucky are released pre-trial. When you look at risk, as you can see, the lowest risk defendants get out 80%. Now these are statewide numbers. If you go by county, some counties are as high as 99% are released, and some are as low as 40%. So these are state numbers here. 62% of moderate and 44% of high. Now what high risk means in Kentucky, I will show you. High risk means that 84% of those released are not charged with a new crime on pretrial release. And about 79% of high risk people come back to court. So that's what high risk means. I always like to say, well, how high risk are they? But granted, there are dangerous people that need to stay in jail. We're not about letting everybody out. But what we do have is the data to show that when pretrial defendants are released, most of them do well on pretrial release. And again, the judge's discretion goes into this. So you may have somebody that's charged with a heinous crime that comes back low risk because they don't have a criminal history. The judge more than likely is not going to release that defendant. On the other hand, you could have somebody charged with something, a minor offense, like operating on a suspended license, but because they have a history of failure to appear, their record's longer than my arm, they're coming back high risk. Oftentimes, judges use their discretion to go ahead and release that person on recognizance, even though they're high risk. So they do look at charges. Our statute requires us to use risk assessment. Our criminal statutes require us to. The criminal statutes require us to be evidence-based. So we can't just make this stuff up. We have to have these outcomes. Our statutes require it. And judges, of course, in their discretion, can release or set a money bond however they choose. They just have laws that they have to go by, the amount of bail, there's things they have to consider, but for the most part, their discretion. And this is, actually I had another one on there. I also wanted to share with you too, when you talk about jail populations, and I think that was one of the topics of this morning, our pretrial jail population is right at 40% of capacity. And I say capacity, so if there's 100 beds in a jail, 40 of them are held by pretrial defendants. The remaining 60 are either empty or there's a sentenced inmate in that bed. So we look at jail population as capacity as far as total population. And as of the 11th, we had, or the 10th, there were 7,900 defendants awaiting custody, pretrial status in Kentucky jails. And that again is only 40% of capacity. Our case processing is rather quick in Kentucky as well. When someone is held in jail unable to make bail, the average length of stay is only 109 days. If they're released, it's 56. So defendants move rather quickly, and again, that's why we don't want to spend a lot of our resources supervising people. They're only with us for 2 months. So we try to reserve our resources for those higher risk defendants so that we're able to get into every jail in Kentucky and get a bail decision within 24 hours so people don't languish. I think my time is up, so I will be happy to answer any questions when it gets to that time. Thank you.
Thank you. Great, thanks so much. Our next speaker today is Judge Ryan Patrick. He was appointed to the 177th District Court on August of 2012. And when he was appointed to that court, it was the second most backlogged court in the entire courthouse. However, that's changed greatly. There's a new docket management pilot information program, and under his leadership, is now the most efficient court in Harris County by almost every statistical measurement. In 2006, he was sworn in as assistant district attorney and served in the justice courts, juvenile courts, as well as chief of the misdemeanor division, and also in numerous felony district courts. During law school, some people may remember hearing him on KSEV filling in for his dad, our next Lieutenant Governor, Dan Patrick. So please join me in welcoming the Honorable Judge Ryan Patrick.
Well, thank you all very much for having me this morning. I'm going to take a little different tack on the pretrial side of things and talk a little bit about the technology side of things and sort of the numbers and what we're doing as judges to try to move cases more efficiently. And I say that because I recently became chairman of what we call our JIMS, for those of you from Harris County, the JIMS Executive Committee. JIMS is our Justice Information Management System that is based on 1970s mainframe technology. And for those of you who speak geek speak in here, we are moving everything to SQL servers, web-based. It's a fully integrated system that will bring together off-the-shelf software packages in addition to anything that we build locally through our IT departments. It's a massive multi-year, multi-million dollar project, and I lucked into being chairman because when I got on the committee, it turns out the felony district court judge is chairman of the committee. So the sheriff's on it, the district attorney's on it, along with representatives from all the different stakeholders. So one of the things I want to talk about, and it also goes into a little bit of some of the things you've already heard, and so I'm going to throw some numbers at you to give you a feel of where we are in Harris County and sort of how we got to where we are. I don't know if this was done on purpose or not, but coming from Kentucky, the population of Harris County is approaching 4.5 million, which I think is just a little bit bigger than the state of Kentucky. So actually, and I don't say that as a put down, I say that as because whatever they're doing in Kentucky could potentially scale very well to Harris County because we're dealing with the same numbers. Now that being said, when we look at pretrial and we look at numbers of inmates coming through the system, new defendants, not cases but defendants, the last time, again this was touched on, about courts, there are 22 courts like me, 22 felony district courts here in Harris County. There's 15 misdemeanor courts. The last district court we got was Judge Ellis's court, the 351st in 1985. The population of Harris County in 1985 was 2.7 million. We're approaching 4.5 million. In the 2 years I've been on the bench, the average felony court docket has increased 15%. So in an average docket of about 700 cases, and I think the average is up to about 730 now, 700 cases, 15% is 105. Now my docket is down 15% since I took the bench, and I'm still working on my backlog. But that goes to show that while filings are flat numerically over the last couple of years, TDC population is down and projected to be flat by the Legislative Budget Board. Deferred adjudications are flat. When you take that into the amount of people coming to Texas, you can only deduct from that crime is down. So if as a percentage crime is down, we are housing at the same raw number of people wherever they are in the system, but our average dockets are climbing, and most of that is pre-trial. There's a disconnect there. My assumption is, and it'd be great to have a study on this, is a lot of that has to do with kind of the CSI effect of our criminal courts. There's just more stuff to be done. There's more to be tested. There's more awareness of it. DWIs now, with all the blood testing, DWIs in particular, are really weighing down and strangling the trial dockets in misdemeanor courts. So that's one thing to look at. So I think it would be great to look at what the cost benefit is. I've heard anywhere from $1 million to $1.5 million cost to have a new district court in Harris County. What's the cost benefit of adding a half a dozen felony district courts? Whether that's reassigning some civil courts or just creating more district courts, what will that do to our overall numbers? Will that help reduce jail population? Will that move cases more efficiently? Of the Harris County jail population, 2/3 of them are felony pretrial inmates of the whole population. And of all the pretrial inmates, about 89% of those belong to the felony courts. But when you dig into those numbers a little deeper, it tells you something very interesting. And this goes back to risk assessment, which is so important. And that is 90%, and for those of you here, you're aware of our bond schedule. And I'm not here to comment whether or not the bond schedule is a good or bad thing. I think it needs to be addressed and looked at and broken down probably more specifically. But 90% of the people who are in pre-trial on a felony, that have a felony bond, 90% of them are above the standard bond schedule for the charged crime, which means somehow the risk has bumped up their bond higher than the standard bond schedule, which means most likely they're repeat offenders. They're habitual or repeat offenders. So if they commit crime A, which should have a bond of blank, but their bond is higher, that bond schedule bumps them up because of their previous criminal history or some other aggravating factor. So that's very important to look at too, where 90% of our pretrial folks are above their standard bond. Well, there's a reason for that, I believe, most of the time. One of the things that was said, bail on probation revocation. I grant bonds all the time on deferred adjudication and probation revocations. I don't know about the other judges. Statutorily, you have no right to a bond on a probation revocation. You do have a right to a bond on a deferred adjudication revocation deal. Now, some of the things that we're doing in Harris County I think are working very well that goes into risk assessment is every morning at 6 a.m. I get an email. We call it an orange sheet. And that orange sheet is all of the mental health and mental history of my new inmates, and I get that from MHMRA every morning at 6 o'clock. It's an email. And everything that person has touched, that any contact they've had with MHMRA, going back as far as the records are, we know right away what meds they're supposed to be on, what services they've had. Are they missing something? Or in pretrial, did they tell someone, hey, well, I haven't been taking my meds? Is it a drug case? Are they self-medicating? Are they having, does the defense attorney come out and say, I can't talk to this guy, he doesn't know where he is? Well, let's stabilize him. Let's get him on the meds that 2 months ago a doctor said he's supposed to be on. Let's stabilize him, come back in a few weeks and see where we are. So we know that data at our fingertips right away. One of the other neat things we're doing, particularly through the gym system, is recently the contract was done for the new jail information management system, the new booking system. And if we ever get to the processing center with the city of Houston, which provides 41% of the county inmates, then we're also looking at business processes. Why is it taking people longer to get to the risk assessment? Why is it taking longer people to see a magistrate, to get a bond set? Well, because, this, that, and the other, and here are the business processes. Well, they got to see medical. We have to release somebody who's going to have a heart attack on us. I get that. But now, the technology, with the restrictions on business processes and technology, we're getting to the point where the technology is going to allow us to be so much more flexible. One of the other things coming back, and I'm running out of time, real briefly, when it comes to pretrial issues, anybody have any idea what one of the biggest speed bumps is we have now? One of the toughest nuts to crack on monitoring, particularly drug offenders or people we want to keep track of at their house? Phone lines. Phone lines. People don't have phone lines anymore. And so the cellular-based systems, and John Burns from Burns Belmont, his son gave me some numbers. Someone with an ignition interlock, that's $70 a month. Someone with the in-home device is $100. Well, that requires a phone line. Well, if you don't have a phone line, I haven't had one in 7 years, well, then you can get the radar device, which you wear on your hip. That's $180 a month. If you want them to have the RF, the dog fence thing on their ankle, that also requires a phone line, but that's $7 a month. The GPS bumps you up to, that's $7 a day. Then you bump up to $8 a day, so you're going from $200 to $250. Or if they have a phone line, they live in an apartment complex with new digital phone lines or voice over IP, like many of your offices have. The things you can't plug a fax machine into. So it is also technology catching up with what we need as pretrial services, which is one of the toughest nuts to crack. There are people we'd love to let out. We'd love to know where they are, but we don't have the means to do that. And some of it is required under statute for DWIs and things like that. Well, I'm out of time. So I'm kind of a numbers guy and a numbers geek. And that's the way I look at it, is integrating our technology, what we need to do, and what we want to do with pretrial services.
Thanks so much. That was terrific, and definitely gave us a lot to think about, especially with regards to the bond schedule. One of the things I wonder is on those prior offenses, if they consider how long ago it was, because that's definitely very predictive. But our final speaker is Devin Anderson, who is the district attorney in Harris County. She took over in September 2013 from her late husband, Mike Anderson, when she was appointed by Governor Perry. She's been a prosecutor for 12 years in the Houston DA's office, 5 of which she was chief felony prosecutor. And of course, she was state district judge of the 177th Criminal District Court. And she was also had her own practice doing criminal defense work. So she's really seen the justice system from every vantage point and has a great deal of expertise. So please join me in welcoming Harris County District Attorney Devin Anderson.
I'm going to talk about the pretrial marijuana program that we started a couple of months ago, because I think it's the most relevant thing that our office is doing regarding pretrial issues. When I was in private practice, I had a large clientele of young drug offenders. And also as a judge over the drug court, I noticed that young people picked up convictions very early. A lot of it is because they couldn't make bail. They're charged with 0 to 2 ounces of marijuana, so they plead out to get out. They don't want to wait to see if they can get pretrial release. They don't want to wait to see what probation they're going to get. So I wanted to start a program where I would allow people who've never been in trouble before, any age, but I knew it would be mostly young offenders, to have a chance to understand the severity of what they've done, but also not have a criminal conviction at the end of the day. So working with law enforcement, I did not do this in a vacuum. I talked to the sheriff, I talked to Chief McClellan, because those are our 2 biggest customers. That was who I wanted to do the pilot with. I brought in Alex Bunnan from the Public Defender's Office to have the defense perspective, although I provide it myself too. We worked this out. We did not use the cite and summons law, and I want to talk about why not. There were a couple of reasons. One, we had seen what a disaster it was in Travis County, frankly, a 40% no-show rate.
The second was, I think the only way that it will work is if we have mobile APHIS systems in every patrol car. The sheriff does, HPD doesn't. The third problem was that the chief was telling me, so Devin, you want me to tell my guys that they've got somebody in custody with marijuana and that they're going to write a piece of paper, hand it to them, and they still have to go tag the dope, they still have to go write a report, and they're letting somebody stay where they were in the neighborhood where people who live in the neighborhood don't want them there. That's not going to work. You got to be able to take them away from the scene. So dealing with all of these concerns, which is what you have to do when you're making change, you have to take into account existing infrastructure. That was the other problem. We don't have a way to generate court dates yet. I'm not saying none of this can be fixed later, but I wanted to do something quickly. So we wanted to work with what we had now. So what we came up with was, I'm going to give you an example. If an officer arrests somebody for 0 to 2 ounces, Class B misdemeanor marijuana, that's the pilot, and I may expand it later if it's successful. So far it's successful too. That's why I was on my phone. I was making sure it was before I got it. So officer has a guy in custody. Every officer, when they've arrested somebody, has to call DA intake to see if a lawyer agrees that there's probable cause for a charge and what the charge will be. So that is still in place. The officer is going to call and run down the facts, whatever they are, to the prosecutor, who will determine probable cause. If there's none, then we don't take the charge. If there is, then the officer is going to transport the offender to a substation or where the closest APHIS is, the fingerprint identification system. When they get there, they're going to run the defendant's criminal history and APHIS them, because we want to know who we're dealing with and make sure they don't have out-of-state warrants, out-of-county warrants, they're not on probation, because I'm only allowing first offenders with no warrants who are only charged with marijuana. If they got a gun in their car, they're not getting this program. If they have anything else, that sounded wrong. If they have a CHL, of course. But if they have Xanax or something with them, we're just taking marijuana people. So if they're clean, then the officers, and they have done this training with the sheriff's deputies and the HPD, explain the program to them briefly and ask them if they're interested in participating. If they say no, then they are charged, taken down, booked, everything goes the way it usually goes. If they say yes, then we have a sheet that's an acknowledgement form. They acknowledge that they are accepting the program and they are promising to appear at pretrial services, make an appointment with pretrial services within the next 3 business days for an assessment. So far, I'm amazed to report that everyone has shown up. And I really think that's because we know who we're dealing with. I mean, and the transport and the photographing and the fingerprinting drive it home that this is not a traffic ticket you can blow off. Right? You can go to jail for this. And I think that that may be why we're seeing so much success with it right now. I'm not saying it's going to change, but today I have good news. So we have had everybody show up to pretrial, and they get a quick assessment that Dr. May developed, and they either assess at, most of these people are low risk. I just looked at the numbers. The majority are low or medium risk. We had like 3 people who were high risk. If they're low risk, then they have 60 days to do 8 hours of community service. And if they do that and they bring back proof, the charge is never filed against them. If they assess at medium risk, then they do an 8-hour cognitive class because they have some criminal, what do you call it, Cappy? Criminogenic factors. See, I'm surrounded by smart people. Just listen to them. And so that's to address those issues with them. And then if they do that, then the charges are not filed. So if they fail to show up at pretrial, if they fail to do the community service or anything, the district attorney's office then files charges. Because we do have the officers tag the dope, write the report, and our investigators can then do the affiance and file the charges, and a warrant will issue for their arrest. So what are the benefits to this? Because again, my motivation is not about money. It's about public safety, and it's about trying not to keep creating classes of convicted people who are then sucked into the criminal justice system for the rest of their lives. But hey, great side benefits is we save booking costs. These people are not booked into the county jail only to spend a day and a half there and then book right back out. And I'm going to call on Judge Cosper again. What are booking costs for, I can't remember, approximately? I know it's
about 200.
Yeah,
In
okay,
addition
and
to
Flores is here too.
depending if they have mental illness, if they're on medication, it varies.
Right.
250 is the
So we're saving that. But also, they're not going to court. They never go to court. So that keeps them out of our building, and everybody knows about our building. So that's a good thing. I want to say also that we have this program already instituted. It's been in effect for I don't know how many years in the juvenile division of our office. And it has an 88% success rate. And it's not just for misdemeanors. It's for a lot of nonviolent misdemeanor offenses. So when I say that I'm talking about expanding this program, I'm seriously going to expand this program if the success rate continues. First, I'm going to open it up to other agencies, and we'll train their officers, and then I want to expand it to different offenses like criminal trespass, low-level, nonviolent offenses. And the last thing I want to say is that we are in the process. There's a committee that's interviewing for a pretrial director. The hope is to get someone of the quality of Dr. May, and I'm going to give her a shout out because she has done the impossible, which has gotten 22 district court judges to agree on a way to deal with probationers and assess them and have the probation department put the conditions on the probationer, not the judges, not the prosecutors. We are happy to be out of that business, by the way. I think we're going to see a lot more success in the probation area. We want to do that in pretrial. So they've got 3 finalists they're interviewing in the next couple of weeks, and I think you will see revolutionary change in the Harris County pretrial with the hiring of that director. That's my hope. All right,
Well, that session's terrific, and I want to extend an invitation, not that you need one from me, but also to both you and Judge Patrick, come up to Austin during this session and help educate our legislators on the great things that we're doing. Because I think a lot of, as much as we think this is great for Harris County, I think the other jurisdictions in Texas and a lot of our state leaders can learn a lot from these advances. So with that, let me, every speaker did such a great job being succinct that we're in real good shape, I think, to have a real lively question and answer session. So let me go ahead and turn it over and see if we have some questions. I have one or two myself, but I'd like to go to the audience first. Back there.
If you'll come up to the microphone to the center and have it kind of stretch.
Thank you.
Good morning. My question references something that Judge Patrick spoke about, as well as Mark, but maybe either Tara or Matt can answer it. You spoke about people in the county jail having bail set at an amount higher than on the schedule, which indicates that they have prior, so that might make them higher risk. I'm not sure to what extent that's been correlated with the risk score they might have on the pretrial assessment, but my question is kind of, because the bail schedule doesn't look at the whole person, it's very crime-based, not person-based. And I know that your foundation's research shows that crime is, or priors are very important, but I'm wondering, in Kentucky, are you supervising people who have a lot of priors, and the risk assessment that you've developed, would it allow for people, or classify people as low or moderate risk, maybe releasable, just with priors?
Do you want to answer the Kentucky part?
Yes, what we find is most people do have priors, but not significant priors. So to be the lowest of risk, you have to have no record. I mean, to be the lowest score, it's no prior criminal history at all. But you can still fall in the low risk range and have a criminal history. You could have a prior felony conviction or a prior misdemeanor conviction. When you get into the high risk, it's more of multiple failure to appears, multiple violent criminal convictions, and a more serious record. But we have people with pretty long records that are coming back in the high end of low and the moderate range that do have prior convictions, but it doesn't necessarily put them up into the high risk. And yes, we supervise people with all types of criminal histories.
Okay, next one.
My question is on a first chance intervention. I was just curious. I heard that you take looking photos. I wondered what you do with those photos, or if those are released, because a lot of the trouble with people is having a photo on the internet. So I didn't know if that, got out to that point after they were actually charged with crime.
No, my understanding is, and I don't know about the photo, I know about the APHIS is run for identification purposes only, so there's no record of that that's kept. The criminal history is the same way. There's no record. The record that will be there for defendants will be the offense report. And we are allowing immediate expunction with no waiting period on this program. So the only record that ideally will be kept will be by our office, because we don't want people to keep coming back and getting the program.
Hi, I have several questions. The first one is for Judge Patrick. When you talked about possibly adding more judges because of their workload, we found that more judges doesn't always mean that they're going to do more work. So,
Just call me.
I feel like it is. However, I'm wondering, is there a way that you're going to monitor that they're actually going to do more work, or you're just hoping they are?
Well, that's one of the, and I didn't have time to get into it. There are 5 of us working on a new docket management program. We are scheduling our cases completely differently than the way we've been doing it in Harris County, time immemorial. And what our benchmarks are is time to disposition for certain level of offenses. And the goal is that about 80% of your cases should clear within 6 months to a year, always knowing there's going to be about 20% that are they're a mess, they're hairballs. And my goal is, if you want a trial, a jury trial, to get you on the docket within a year. And my newer cases, that's being successful. So the buy-in is getting cases more efficiently worked and getting the buy-in there. And that's what I mentioned. I don't know what the correlation is between adding more courts and the efficiency. And that's one of the tricks here in Texas is everybody who's in this system, in our criminal justice system, for the most part, is an individually elected official. We are all islands unto ourselves. So we don't really have to cooperate or corroborate with anybody. And that's what Caprice Cosper's biggest job is hurting all of these individually elected cats. So, look, you're always going to have judges who are going to work the hours they want to work, and you're going to have some that don't. So, I think someone really needs to look in to see what is the cost benefit and what are the projections by adding not just 1 or 2 courts, but I'm talking about a half dozen or more, which our population would dictate. We need some, because that's just going to be an efficiency driver in moving cases, because it's going to just spread the workload.
The next question for you is, you talked about getting a mental health list, and I would imagine that's very helpful. So do
Yes.
all the judges get that?
Yes, every judge gets, we get emailed that list from MHMRI. The data is coming from MHMRI. I don't know exactly who sends it to me, but it comes from MHMRI, and it's every contact they've had as far back as their records indicate.
The next question is from Steve. You talked about the pretrial doesn't supervise all those. So how many right now are they supervising those?
Of the 171,000 that were released, 17,000 were referred to supervision, and our active caseload as of yesterday was right under 6,000 on supervised release, and then the remaining 165,000 we still monitor for rearrest and FTA.
The last question is for the DA, and I commend you for that program. I think that is wonderful. I have that's one of the things I feel we waste a lot of money on time, and is with those that are arrested for under 2 ounces. So I think that's a wonderful program. And do the defendants pay anything to be part of that program?
Yeah, there's a $100 fee that pays for the class, really. And if they can't afford it, we have an indigency program.
Thank you.
Yeah.
Thank you very much.
Well, one of the issues that we have a lull here in the questions I wanted to ask about was indigent defense, because that is one, as much as we try to involve everyone, of course, Devin Anderson is a former criminal defense lawyer, but we don't have a criminal defense lawyer speaking today. But some of the things that we've kind of heard about quite a bit is issues of people pleading to time served, sometimes even who didn't commit the offense, but just to get out of jail. But oftentimes where you might have a criminal defense lawyer who has an enormous docket and may not have the opportunity to fully investigate the facts of a particular matter. So I wanted to kind of see if any panelists could comment on how strengthening indigent defense representation could help with some of the issues that we've already been discussing today.
In Kentucky, our public advocate's name's Ed Monahan, and somebody in the audience had already talked about him, and he goes all over the country and answers questions about pretrial, so I guess I can answer a question about his realm. So if I misspeak, I apologize, but one of the pushes in Kentucky through our public advocate, Ed Monahan, was to have a public defender at every arraignment, And just to give you a little, the way that Kentucky works, the initial bail decision is done over the phone. There's no prosecutor present. There's no public defender present. It's a non-adversarial process. It's basically based on the defendant's charge, their risk assessment, and the recommendation of pretrial. But those that don't get out, meaning if a judge decides to use money bail at that initial phone, then they're taken to what we call jail arraignments, which they're in custody and then they're arraigned. And that at that point is where there is a public defender in all but one jurisdiction. So in all 120 counties, we have a public defender present at that hearing or that arraignment. So again, that's a push by Ed Monahan, and he can rattle off numbers on how he feels that having the presence of the public defender, that the defendant's more likely to be released with less conditions and blah, blah, blah. I don't know those numbers because it's not something I track, but he has definitely said that it has made a difference, at least in Kentucky.
And the only thing I would add to that is in Harris County, if you are in custody and indigent, and you notify the court that you want an attorney appointed to you, you get one that day, whether it's through our appointment system or from the public defender's office. And I will say historically, I mean, just in my 2 years and also being a prosecutor for 6 years, defense attorneys in Harris County don't ask for pretrial supervision. I mean, they're just not asking for it. I mean, they ask for bonds to be lowered, but they really very rarely ask for pretrial services to really get involved. I think because the assumption is the answer is no. And I will say as a judge, and this is my track record on pretrial personal bonds, those folks, their failure to appear rate and my track record with them is far worse than those on a commercial surety bond. Not that I have problems with them, but they're the ones who are not reappearing. Those are the ones who are reoffending small crimes. They're usually dope cases. They pick up new cases. So there's a gap somewhere in our assessments.
Mark, I
okay.
I know I've spoken a lot. Does maybe I just have the mic for 30 seconds more. Judge, you talked about the number of courts.
Yes.
That was one of the things when I came here and spoke with the DA's office. I already shared my home county was Orange County, California. About a 3.2 population county. They have 124 judicial positions and 20 additional court commissioners. So they have 144 bench officers. About 60% of them are doing criminal cases. So to think that you've got 22, and that was shocking to me, 22 courts, and then the 15 additional misdemeanor courts, that's a very, very small especially for your population, your workload. But that's where I wanted to go with the question about the defenders. I've been speaking especially on behalf of prosecutors, we can do some really great things with cases. And District Attorney Anderson already pointed out, look, this is an alternative, but it takes more time. You need to slow the system down. So it's not when you do alternatives and do a better job, it's not as though now that cases are diverted, you don't need to staff it. And there's a real frustration with prosecutors' offices that they're getting rid of cases. Milwaukee's a great example. About 30% of the cases are getting diverted out of the system. And then the state looks at it and cuts the size of the prosecutor's office. It needs to be the other direction. We need resources. I started with the judges. We need additional judges so they can really do the individualized. But we need additional prosecutors and defenders. I'm going to be balanced. But you need a defender in this as well. The system can do it, and if you invest in that sort of that front end, then ultimately your jail costs, your prison costs, and other things can go down. But it's very short-sighted with many of the funding organizations to say, oh, your caseload's down, therefore you've lost positions. So I just wanted to bring that forward as we're talking about the judicial and the defense. Don't forget the prosecutors, because there's a lot of work as you work towards alternative dispositions. Thank you, sir.
Well, I mean, yeah, that's a great thing. And then the other thing is, you get some of these marijuana cases, the ones you're getting out of the system are the ones that probably require the least work. It's the same phenomenon in the juvenile system. Of course, our juvenile incarceration is down dramatically in Texas, 2/3, but those that are left are among the most serious offenses, serious mental health needs. But you don't want to address that?
Sorry?
You don't want to address Dave's comments at all?
I would just say I want to go ahead and extend the sob story for the prosecutors because we're the third largest county in the country. LA has 1,000 prosecutors. Cook County is number 2, and they have 600, and we have 300.
Ashton Cook is 850.
Oh, wow.
And LA is 1,100.
Okay, I had changed my numbers. I got to go talk to the commissioners again.
And I want to bring up LA. because I'm a Lawrence County boy. LA is 1,100, and they're all felony prosecutors. They don't do the LA City misdemeanors.
Well, we've been in budget discussions, and I just found out that the average term of employment for a Harris County employee is 11 years. In the DA's office, it's 8. And it's because of burnout. There's no other reason for it. Oh, and the salary.
Well, and I think you make an interesting point that like one of the areas we worked on a lot is victim offender mediation. The bill was passed last session creating criminal ADR, amending the civil ADR statute, but somebody needs to look at that, which is the prosecutor, to decide, okay, this is a case where we should see if the victim would be interested in doing that. And so just the time to determine the case is appropriate for a certain diversion is time that has to be spent.
One of the issues that this discussion brings to my mind is the role of the defense attorney and, guilt and innocence as opposed to risk. And as a prosecutor, you're evaluating risk, but you also have to take into consideration whether you're going to win your case and if you go to trial. How are you balancing those things? How are you balancing someone who for example, you have a DWI. Maybe they're high risk, but it is a bad case for the prosecution. How are you managing that?
Well, if we don't have a case, we don't have a case. And that's the end of the discussion, and public safety or not. We will do everything we can to build up a case, make sure we have one. If there's another charge we could file, we could do it. I mean, when we have a dangerous person, it's very disturbing when you realize you can't prove the case beyond a reasonable doubt. But our oath is to seek justice, and that's it. There are no ifs, ands, or buts about that. We have to get rid of the case.
What about the issue I'm concerned about defense attorneys really balking at the criminogenic risk assessments. And I don't know how that's gone in other communities across the country. I can imagine that, their job is not necessarily to seek justice for the community, and their job is so different. We have a mental health public defender who, in my jurisdiction, who takes a different approach to helping their clients, but that, there's a real friction there between kind of old school defense attorneys. I don't know, how do we bring them along to help them realize that, in the long haul, having a risk assessment and having appropriate services to their client is good for their client in the long haul. I mean, I don't know. Any thoughts on that?
I mean, I'll add this is a real world experience that happens too frequently in my court. Let's say you have someone who's on a probation for a drug case. This happened the other day. And he went through a program, he went through like a 9-month program, successfully completed it. He relapsed, he's back in front of me. I was more than willing to put him in a relapse track program. He wanted no part of it. He wanted his back time and be done with it. And I brought him out. He had a very good defense attorney. Most of you would know in here, very respectable. He said, hey, will you bring him out? I mean, the two of us read him the Riot Act. He was 19 years old. He didn't care. He just wanted his TDC back time and be on his way. The other trick bag we run into is this. If they want to do the assessment, an attorney will come up and say, hey, here's the guy. He's got a record. It's an old record. It's a drug case. I think he needs treatment. Can we do the assessment pre-plea? Because I want to see what it says first. And I did that. I stopped doing it because too many of them came back, and I would tell them, whatever the assessment says, if I give them probation, I'm going to follow that. Because someone smarter than me has said they need XYZ program. Well, then that inmate sees the program and goes, forget this. I don't want to do a year lockdown. I just want time. So we've wasted everybody's time and resources. So that's the other thing we've got to factor into this is when we talk about treatment, particularly on the plea side, if the defendant doesn't want it, there's nothing we can do about that. I mean, I can shove them in all the programs, but at some point, some people just go, I don't want treatment. They're not there. They're not to that point in their life yet.
Now, let me note, Judge Patrick is not in my pilot yet. For those of you who don't know, I'm Dr. May. Someone's talked about me a little bit today, but I'm the director of the probation department. And some of the frustration Judge Patrick is talking about is the very reason that we are redesigning how we're doing assessments in Harris County. And right now we have 3 of his colleagues on the new assessment process. Part of it is, with the defense bar, it's an education process. You know, defense lawyers hear risk assessment and they freak out. You know, they're like, you're going to say, my guy's high risk. And really what it is an education into, yes, it does tell us what the risk level is, but it's also a risk reduction, risk management plan, which is really, really important to keep in mind. And yes, some of the 19-year-olds are very frustrating and very stubborn in terms of what they want. But in addition to getting a good solid risk assessment, and we're moving to the new Texas risk assessment, we are also screening for mental health and substance abuse, and it is either pre-plea in our pilot, pre-plea or post-plea pre-sentence. And right now I have 3 felony courts that have been doing that now for about 5 months. And so far, the feedback from the judge, same fear Judge Patrick just mentioned, is how we present the data. So if we make a recommendation for residential treatment, or we make a recommendation for outpatient treatment, I'm going to explain exactly why. And there's a nice report summarizing, here's what's going on. My experience with most defense attorneys, they know. Or it can be also enlightening. So one of the feedback I have from Judge Patrick's colleagues so far that are in our program are telling me, you know, the reports are balanced, they're fair, and they're clear. Plus we bullet point some things and it's really quick and easy to look at. And there are color charts coming. So that also helps to get a quick perspective. But it is doable. You know, it's an ongoing thing, but it is doable. We're seeing some real progress with it. I've done this before in other jurisdictions, and I know it's doable. It's a big shift. It's a big shift. We'll try to get Judge Patrick on our pilot as soon as possible.
I do the assessment post plea pre-sentence. So I have them come back, but when I sentence them, I let them know, you know, here's what we're doing, and if you get, you know, if it says you're going to this residential, I'm going to follow that. And then sometimes they go, well, let me talk to my lawyer to work something out. So sometimes it gets even, we cut it off before we even get that far.
Right, it does. And, you know, I've seen a few different things. One is, the new process really is designed, you're going to get probably more quality than you're getting right now, because we actually have clinicians doing the substance abuse and mental health assessments, and they're going to get some things in combination with risk assessment that's going to be more specific and more helpful, and they would have talked to the client a little bit more ahead of time. So I think that information will be helpful. There are always going to be some.
And by the way, I'm a huge Dr. May fan, by the way. So.
You ought to go to HCCLA and the PD's office and do some training.
Well, actually, we have already been in discussions with our, where's our defense bar? Are they here?
Alex is here.
Right there.
Alex. Oh, I'm sorry, Alex. I'm so many meetings with Alex. She's like my neighbor. Alex, yes. PD's office, and Alex has actually been very attentive. And same with our defense bar. Good. And so we're working with Carmen right now to set up that X training, and we'll continue that. And I have to applaud it was Judge Anderson, now DA Anderson. She had mandatory training for every felony prosecutor on our new assessment tool, and also really taking a hard look at the data and what's happening in Harris County and what the outcomes are. And it's eye-opening. So I'm going to sit down and shut up, and I'll be visiting Judge Patrick next week.
Can I add something on the defense bar side? I think some of the perception there often tends to be that we're at whatever baseline we're at, and adding a risk assessment is just going to apply upward pressure. It's going to identify the high-risk people. What we've seen in a lot of places, at least with places with our risk assessment, is that if you take violence, for example, in most data sets we look at, 6, maybe 7% of defendants are flagged as being at an elevated risk of violence, and they're at a very elevated risk of violence. In Kentucky, the data we've seen is that if they're released, they commit violent acts at a rate, I think it's 17 or 18 times of defendants who weren't flagged. So it's a small group of people, but they're they're at very elevated risk. And that's consistent with what you see in a lot of literature, that there's a small group of people who tend to very disproportionately commit crime. And so I think that it's important to emphasize that and say, we care immensely about making sure we're doing the most to protect the public from people who are really high risk. But that's actually not everyone. In fact, it's a pretty small percentage of people, and you can see sort of the impacts in Kentucky where they've actually increased the percentage of defendants, not by a lot because they were already releasing a lot of defendants, but they've increased the percentage of defendants released and decreased pretrial crime, right? And so the hypothesis would be that they're changing the mix of who is detained, and they're detaining more higher risk people and fewer lower risk people. And so it's an ongoing conversation, but I think there's pretty good data to talk to the defense bar about what the impacts really are.
I just want to add that, and the only issue that our public defender's office has had at all with anything we've done in the past 40 years is the elevated risk of violence flag. That's it. That's the only thing that they've had any issue with. They support everything else, and it's just a way of educating them on what it actually means. And like Matt said, a very small percentage of people are actually flagged.
Well, one thing I wanted to mention with respect to what Teresa said is that one of the bills that will be heard again next session, Texas, would allow someone who's completed 2/3 of their probation successfully for a state jail felony, which is mainly less than a gram of drugs, to apply to have that reduced to a misdemeanor. It would have to be signed off on by the district attorney and the judge for that to happen. But the idea is that a lot of state jail felons who are now choosing to go to state jail over probation, since they might go to state jail for 6 months versus up to 5 years of probation, this would be an incentive for them to take probation and to be successful on it and complete programs. But I absolutely agree, certainly someone's got to be willing to do the treatment, but if we can provide an incentive where ultimately you don't have that felony on your record, I think that will help. We got another question down here.
Well, I was going to ask Sheriff Garcia, but I'm going to put this towards Judge Patrick, and this is the illegals. I'm just curious from your experience now, because they've not been talked about in the sense of jail population, how the illegals impact both your court docket and our jail population here in Harris County.
I've seen the numbers. Caprice Cosper gave me some numbers the other day. Our ICE detainer, well, at least people who have a known ICE detainer on them, it's a pretty small percentage. It's less than 5%, I believe. Some counties, well, El Paso County, I think it's 23%, but I think they have a deal where they house federal inmates. I don't see it as a big docket clog necessarily, and I don't see it. Well, we have a lot of inmates who come through, a lot of defendants who are illegal. The only hiccup there that I see is when you get into people who are residents on a deportable offense who want probation, and then as just a public policy issue, you get into, well, if someone's going to be deported, then we have this open-ended probation that sits there indefinitely. So that's really the biggest hurdle and sort of speed bump in that system is someone who is deportable, likely going to be deported, or is a straight-up deportable offense, and just resolving those cases.
Okay, one more. I got special dispensation.
Sorry. So I'm a brand new defense attorney, so I hesitate to speak for the entire defense bar. Alex, I apologize if I step on anybody's toes, but one of the issues that I've seen in some of my cases are that to do the risk assessment, the cases have a lot of innocence issues as well as assessment issues, and so a lot of times the prosecutors and judges come from a mindset where everyone through the system is automatically guilty. But there's a lot of innocence claims in all these cases, and you have to give all of that up for the risk assessment. And there's a lot of rights that the defendants have based off those innocence claims. So how do you ensure that you're protecting those innocence rights while still assessing risk and allowing someone to get help they may need?
I think there's some confusion on what a risk assessment. What we do in pretrial is a risk assessment for a bail decision, and we would never ask any information about a charge. It's completely objective. What Dr. May is talking about is a risk assessment for probation conditions, which would be, once they're convicted. But yeah, we don't, the legal principle of presumption of innocence is 100% what pretrial does. We do not even speak to the defendant about their charges. If they even begin to say anything to us, we cut them off. So the risk assessment we use is very objective, and basically it's from the charging documentation and the criminal history, and that's it. So, but the risk assessment that the judge was referring to on the sentencing, that's a probation risk needs where they look at criminogenic factors. The pretrial risk assessment for the bail decision has no criminogenic factors whatsoever. We have a needs assessment that we do in the office if they're on supervision, which is similar to probation, but the bail decision is based on the objective risk assessment that measures failure to appear and rearrest pretrial. Not long-term recidivism, not anything else other than their likelihood to appear in court and the likelihood, if released, that they would be allegedly charged with the new offense on pretrial release. So I hope that clears that up a little bit.
Yeah.
We don't ask anything about substance abuse or mental health or charge or anything.
Thank you.
Okay.
Mike, that's it? No more questions?
Well, it's up to Mike. We have to go. One more.
Last question. Mark, thank you for letting me know you're doing this panel. Nick Wojcinski, American Bail Coalition. I've met Tara and Matt before, and Mark obviously been working with you for a long while. And listening to the gentleman's question, it's a two-part question, but they're very easy answers, so I promise Mike won't take long. First things first is, I travel the states just as much as you guys do. Colorado is a state that's been exploring risk assessment. In my last tenure, this past session in Colorado, I was confronted both by the prosecutors, defense, and defense attorneys, suggesting to me that the risk assessment, while it doesn't measure criminogenics necessarily, has been used or abused by certain prosecutors in negotiating or making plea offers. In fact, if it's a higher level risk score, they just won't give you a plea offer. So for whomever wants to answer, how do you address that when you do risk? And then the second question is, again, just full faith and disclosure of who I speak on behalf. I'm the American Bail Coalition. We advocate best practices in pretrial realm, relying on the commercial bail industry because we recognize their value. And for whoever wants to take a stab at this on the panel, I didn't hear anybody recommend we should get rid of commercial bail. So what is your vision on how they fit into this risk assessment, risk needs responsibility? And again, Mark, thank you so much.
I really can't answer that because we don't have commercial bail. Here they do, so I think I'll refer to my Texans here.
We
don't have it.
The only thing I would say is, when it comes to commercial bail, my experience tends to be that they or a loved one has some real skin in the game to make sure they appear and don't reoffend. I mean, that's my experience. I don't have an experience with a non-commercial bail system. But like I said, I don't give a ton of personal bonds, but I have given them, and the track record, quite frankly, is pretty poor. And so, like I said, it's just a whole system that needs to be looked at, particularly here in Harris County.
And I would say, since I've never seen a risk assessment for bail, I'm kind of in the dark here about what it would look like, but I just know that when we are crafting a plea bargain offer, we're looking at what the person has done, and we're also looking at what they've done in the past. So what they're accused of now and what they've done in the past, because we're looking at it from a public safety standpoint. And so do they need drug treatment, and can we rely on them not to hurt anybody, or that kind of thing. We'll offer deferred or probation. If we think they're a danger, we'll offer pen time. So I think we would use the assessment. I don't think there's anything wrong with that because we're trying to assess the person and how we craft the best plea bargain.
And sometimes I'm presented with, particularly teenagers, look, they've got no money, mom's got no money, they're in school, finals are in 2 weeks. Okay, do they have a stable place to stay? Do they have any sort of support? Do they have a history with mental illness? If they do, are they being treated? Have they had contact with MHMRA recently? Those are the things I'm going to look at to see how stable do they have a place to stay? Do they have any sort of support system to make sure they get them to court? That's what I'm looking at when I'm asked those questions directly, which is rare, but I do it, and I've taken chances on many of those. Particularly, it's almost always young men or young women with kids at home, but it's just the track record it's been poor. And I don't know if you've got what you want to add to that.
Oh, no, I was just going to, I think, Nick, we haven't sort of articulated a position about it, but we have worked, we work in Kentucky where they don't have commercial bail. We work in Arizona and California and North Carolina where they do. They had it before they worked with us, and they have it after. So we kind of think we work with our risk assessment in jurisdictions that use it and don't use it. Likewise, it's sort of the way we treat all the conditions of release or risk mitigation strategies, whether it's electronic monitoring or supervision, kind of go to the jurisdiction. They have their toolbox, and we work with them to, overlay the risk assessment with that existing toolbox, I guess is how I'd say it.
Okay, well, we have wrapped up here. We'll have about, 10-minute break, Mike? 5-minute break. We're keeping us in. And then our mental health panel, and then we'll let you return with fire. Thanks so much.